Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Massachusetts versus David Argo. In this case, David Argo was convicted of violating a restraining order by liking a happy birthday message from someone else to the person that he had a restraining order against. So someone else said happy birthday to the person, and they liked that message. That was deemed to be a violation of the restraining order. At issue is only the issue of authentication, whether it was really him who sent it. Personally, I think there's the issue of whether or not that counts as a violation of the restraining order, but that isn't the issue that's being discussed. But let's read the case and see what the court decided as it relates to authenticating someone in the digital economy. I don't know that that really counts, but that was not the issue that I'm guessing there's case law that says it counts. Seems like a bit much. The trial judge convicted defendant David Argo of one count of violating of an abuse prevention order. Argo argues that the trial judge abused her discretion by omitting the Commonwealth, Massachusetts, key evidence, specifically a screenshot that the victim took of her Facebook notification page. The screenshot shows that a Facebook user named Monte Argo liked a post to the victim written by a third party. The third party's posted stated, "Happy birthday, victim." I'm not really sure that liking a post from a third party really counts violating their restraining order. But I'm not familiar with the case law in Massachusetts, so I would be raising, like, really? That's a violation, liking a post from someone else? Okay. The Commonwealth's theory was that the defendant violated the restraining order, no conduct prohibition, because liking the third party's post, the defendant's like was communicated to the victim in accordance with Facebook's process. Argo contends that the image of the Facebook like was not properly authenticated and thus inadmissible. We disagree and affirm. I mean, again, I'm not an expert in this state nor an expert in this area. In fact, I very deliberately in my career decided not to learn about family law because, like, it's just all sad all the time. It's like, I don't want a piece of this. So this may be the area of law I know the least about, but still, to me as a person, it's like, that seems a little tenuous for violating a restraining order, but okay, Massachusetts, you carry on. In May of 2015, a probate and family court judge issued an abuse prevention order against Argo after Argo published a Facebook post on the victim's birthday containing lurid and thinly veiled threats of violence against the victim. Approximately 1 year later and 6 days before the expiration of the order, the victim looked at a Facebook notification on her cell phone and saw the Facebook user had liked a birthday message. So not only was it tenuous in connection, it's a little tenuous in time. The order was still valid, but it was going to expire 6 days later. And he liked a third party's post. It's like, really? This is the case we want to prosecute this guy? This seems a little thin, but okay, let's carry on. The like was communicated on victim's notification page as follows. Monte Argo liked a post on your timeline. Apparently that is a bridge too far. Okay. As to the restraint order itself, there is a footnote from the court that says, although the parties have not included a copy of the abuse prevention order in the appendix, the victim read relevant portions of the order into the record. Among other things, the order prohibited Argo from contacting the victim in person, by telephone, in writing, electronically, or otherwise, either directly or indirectly through someone else. The victim took a screenshot of the page and provided the image to the Boston Police Department. The defendant was charged and thereafter convicted of violating the abuse prevention order, and the defendant appeals. I'm a little bit amazed the Boston Police Department took this, which seems a little tenuous to me, and decided to prosecute the case. But okay, that's what happened. I don't know, guys. I don't practice in this area. I don't know what's going on in Boston. I would think there would be other cases worthy of their attention. But this is what they decided to do. Okay. The sole issue that Argo raises on appeal is whether the Commonwealth sufficiently demonstrated that Argo was actually responsible for the like. In a footnote, the court notes, we note that Argo does not contend that in the circumstances, the liking of the Facebook post made by the third party cannot constitute a violation of the no contact provision. I don't know why Argo or his attorney aren't making that argument. I'm assuming because there's case law specifically telling them they can't do that. But like, that would be my first go-to. I'd be like, really? 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 This is what we're doing now? That'd be my argument. Really? See figure one, really? But, okay. Both the Supreme Judicial Court and this court have recently addressed the issue of authentication of electronic communications. The requirement of authentication as a condition precedent for admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what the proponent claims. The trial judge, acting as a gatekeeper, determines whether the fact finder could have found by preponderance of the evidence that the proffered evidence is what the proponent says it is. In this case, the Commonwealth did not present direct evidence that the defendant authored the like, nor did anyone from Facebook testify as to what its business records show regarding the account. Our prior case law makes clear, however, that direct evidence is not required and that an electronic communication can be authenticated through circumstantial evidence, so-called confirming circumstances that tend to show authorship by a particular person. Here, the victim's testimony based on her lengthy relationship with Argo furnished sufficient circumstantial evidence for the judge to make a preliminary finding the Commonwealth had authenticated the Facebook like, and thus to admit the screenshot displaying it. The victim had known Argo for 16 years and had lived and had been married to him. She testified over the years she had communicated with Argo on Facebook through her user account. This history of communication was sufficient to support a determination of authenticity. Just as past patterns of telephone communications may suffice to authenticate the identity of a caller, so too may the details and history of communication with a certain Facebook user suffice to authenticate a Facebook post as emanating from that user. Guys, does this make sense to you? Like, what are we missing here? Or what am I missing? I mean, there are a lot of people violating a lot of restraining orders, I'd imagine, in Boston. And like, this has got to be pretty low on the priorities. And like, you'd be like, I mean, does it strike anyone else as odd that we're doing this? Or is it just me? Am I just merely a mansplaining woman hater who, thinks domestic violence victims, to be laughed at or something? Am I just a tool of the patriarchy for being like, what, really? Are we doing this? Is that what's going on? Am I just an asshole, or like, what's going on here, guys? I'm like, why is this a thing? I'm not quite sure. While the confirming circumstances in this case are different from the prior case's holding does not limit the circumstantial evidence courts may consider to the type present in this case. Here, the judge's decision is consistent with our case law. She relied upon considerably more than pure speculation, as Argo asserts, in deciding to admit the screenshot. Judgment affirmed. So that is the end of the case of Commonwealth versus David Argo. In this case, we learned that David liked a happy birthday message from someone else, and that message showed up in the person's timeline, and that apparently is sufficient grounds to violate a restraining order in Massachusetts. To me, it strikes me as a little thin, but that is the law. The only issue at case here was the authenticity, the admissibility of the evidence in question. Admissibility is a preponderance of the evidence standard. Now, as to the ultimate issue of guilt, that is guilt beyond a reasonable doubt. But whether evidence can come in as to admissibility is just preponderance. Is it authentic or not? And then, of course, what it proves or not is up to the finder of fact to find beyond a reasonable doubt. But the issue here was the authenticity. And the question is, was there enough? And the answer seems to be yes. Although no one came to stand from Facebook, for example, to authenticate it, the person who was the victim in this case testified they had received other messages from this username they knew to be this person, and therefore it was authenticated based on that. That was sufficient according to the Court of Appeals. I agree that's sufficient on a preponderance of the evidence standard. I'm a little unclear as to why this case was brought, given that it seems a thin violation, but it was brought, and that is the end of this case.